Good day. We are now in the Provisional Remedies, Rule 59 of the Rules of Court on receivership. So we will be talking about provisional remedies as a continuation of our discussion on this and the rules of court. So in section 1 of Rule 59, it is being said there who is a receiver. So in case of Normandy versus Duque, GR number L25407 in 1969, the court said that a person appointed by the court on behalf of all the parties to the action for the purpose of preserving and conserving the property in litigation and preventing its possible destruction or dissipation if it were left in the possession of any of the parties. So that's how this case or the Supreme Court defined or identified the so-called receiver. Now, a receiver, according to the book of Riano in 2016, this is a book on rules of court, and he defined it as an agent of any part to the action. He is an officer of the court exercising his functions in the interest of neither plaintiff nor defendant, but for the common benefit of all the parties. In other words, a receiver is a neutral party in the litigation, so that as identified or defined in Normandy versus Duque, that if he will not be on that position, the property in litigation will be might be destroyed or dissipated if it were left to the belligerents of the case. So, on the note, it has been said that no action may be filed against the receiver without leave of court. In other words, there should be a leave of court, or the litigants should ask permission from the court first before an action can be filed against a receiver. Okay, so what is the purpose of receivership as identified or defined in the Duque versus Normandy versus Duque case? We all know that it is for the preservation of the property in litigation. But let us look at how it is being defined by experts on the field as well as the rules itself. Now, so receivership, like injunction, may be the principal action itself or just an ancillary remedy. We all know that the general rule for the provisional remedies is that they are provisional remedies. In other words, they do not stand when a main cause of action does not exist. So you have to have a main cause of action so that you can have a provisional remedy from Rule 57 to 61. But just like injunction, injunction can stand alone, as we have seen in our discussion in Rule 58 of our rules of court. And receivership also is the same as injunction. It can stand on its own. But it can also be a provisional remedy attached to the main cause of action. So the purpose of receivership as a provisional remedy is to protect and preserve the rights of the parties during the pendency of the main action, during the pendency of an appeal, or as an aid in the execution of a judgment when the writ of execution has been returned unsatisfied. That is in Isasi versus Fernandez, GR number L28593 in 1968. It was also cited by Riano in his 2012 Rules of Court edition book. So, unlike the other provisional remedies which can be availed of only before final judgment, receivership may be resorted to even after the judgment has become final and executory. Why? Because the main purpose is to protect and preserve the rights of the parties as to the property, as to the 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 dealings of the parties in the main cause of action. So whether there had been final and executory order, the parties can still file a provisional remedy of receivership so that the property in litigation can be protected. Especially if, as what happened in Isasi versus Fernandez, that the writ of execution has been returned unsatisfied. So that is also found in Section 1C, Rule 59, in relation to Section 41 of Rule 39. Okay, so cited by Regalado, 2010 book. Okay. To continue, the receivership under Rule 59 is directed to the property which is the subject of the action and does not refer to the receivership authorized under banking laws and other rules of laws. So it refers to or directed to the property which is the subject of the action. Rule 59 presupposes that there is an action and that the property subject of the action requires its preservation. So that is the main purpose, to preserve the property. The guiding principle is the prevention of imminent danger to the property. Again, as defined or as identified by the Supreme Court in Commodity Storage versus CAGR number 125008 in 1997, it again said that it is the prevention of imminent danger to the property. If an action by its nature does not require such protection or preservation, said remedy cannot be applied for and granted. So, if there is no need or there is we cannot find an ample evidence that there is danger to the property, then the remedy cannot be applied for and granted. So that is what is being said in commodity storage case. So, to continue, letter A, cases when receiver may be appointed. So, let us see what are the cases when a receiver may be appointed. Letter A, when it appears from the verified application and such other proof as the court may require. Verified application. In other words, this is a sworn affidavit, perhaps, that the party applying for the appointment of a receiver has an interest in the party. In other words, he has an interest to that party or fund, which is the subject of the action or proceeding, and that such property or fund is in danger of being lost, removed, or materially injured unless a receiver be appointed to administer and preserve it. Okay? So, letter B. When it appears in an action by the mortgagee for the foreclosure of the mortgage that the property is in danger of being wasted or dissipated or materially injured, and that its value is probably insufficient to discharge the mortgage debt, and that the parties have so stipulated in the contract of mortgage. So, for the mortgagee, this is a protection for the mortgagee so that the property in litigation or in question will not be wasted, dissipated, or materially injured. And of course, so that the value of such property can pay for the mortgage debt. Okay? Letter C. After judgment to preserve the property during the pendency of an appeal or to dispose of it according to the judgment or to aid execution when the execution has been returned unsatisfied or the judgment obligor refuses to apply his property in satisfaction of the judgment, or otherwise to carry the judgment into effect. So what should the party do? They should apply for receivership so that the property in question be protected, especially during the pendency of an appeal. Okay? Or to dispose of it according to the judgment. Perhaps the other party might uh, cause it to be disposed. Okay? Or so that it will be executed properly as the court had ordered. Okay? Letter D. Whenever in other cases it appears that the appointment of a receiver is the most convenient and feasible means of preserving, administering, or disposing of the property in litigation. Okay? So, if there are properties that are in litigation and it would be convenient and feasible for the parties to preserve the property or to have someone to administer or to have someone to dispose or to sell the property, so a receivership can be filed. Okay? Now, what are the specific cases? So we look at the rules of court. This is section 1 actually of the section 1 of Rule 59. You can find it there. It is listed. So what are the specific cases? A. If a spouse without just cause abandons the other or fails to comply with his or her obligation to the family, the aggrieved spouse may petition the court for receivership. Receivership of what? Of properties. Okay? Because there had already been a animosity between the parties, no? The husband or the spouse or the wife, and so that the properties of the family or the properties of the husband and wife will not be in danger of being destroyed or disposed of by the other. Okay, so it does not mean that the erring spouse will cause the disposition, but it can be that the innocent spouse can also do such disposition. So there is this in Article 101 of the Family Code, the aggrieved spouse may petition the court for receivership, so that if there will be disposition, the aggrieved spouse will not be in default, no, or will be filed with fraud or fraudulent contracts. Okay? So letter B, the court may appoint a receiver of the property of the judgment of Obligor, and it may also forbid a transfer or other disposition of or any interference with the property of the judgment of Obligor not exempt from execution. So, if the property of the judgment of Obligor, it may also forbid a transfer of other disposition. So, if there is a judgment of Obligor, the court may appoint a receiver of the properties of such judgment of Obligor, so that in the event that there are judgments, or in the judgment, the judgment of Obligor will execute properly the order of the court. So there should be a receiver. That is in Section 41, Rule 39 of the Rules of Court. Okay? Letter C. After the trial court loses jurisdiction over the case, especially in appeals by notice of appeal, or only over the subject matter in appeals by record on appeal, and prior to the transmittal of the original record or the record on appeal, the court may issue orders for the protection and preservation of the rights of the parties. Section 9, Rule 41, including necessarily the authority to appoint a receiver who has the power to take and keep possession of the property in controversy. So that is found in the case of Acuña versus Calawag, GR number L10736 in 1957. After final judgment, a receiver may be appointed as an aid to the execution of judgment. Okay, so again, the receiver can be appointed as an aid to the execution. Okay, that is found in section 1, isn't it? Letter C. So that the execution will be correctly executed or will be complied of. So that is found in Philippine Trust Company versus Santa Maria, GR number 31951 in 1929. And letter E, appointment of a receiver over the property in custodia legis may be allowed when it is justified by special circumstances, as when it is reasonably necessary to secure and protect the rights of the real owner. So that is in Dular versus Sundiam, GR number 27361 in 1971. So property in custodia legis. In other words, the property in litigation. So that is under the custody of the court. May be allowed when it is justified by special circumstances. So if there are special circumstances, a receivership should be appointed by the court. Okay, who appoints a receiver? So in section 1, rule 59, again, it is listed there, or it is in the first paragraph of section 1. It says there that the courts where the action is pending, okay, that is the court that appoints a receiver, the Court of Appeals, and the Supreme Court, or any members thereof of the court where the action is pending, or the member of a Court of Appeals, or any member of the Supreme Court. And during the pendency of an appeal, if there is an appeal, the appellate court may allow an application for the appointment of a receiver to be filed in and decided by the court of origin. So, the appellate court can appoint, but it can be filed and decided in the court of origin. So, the court below it. Okay? So, what are the requisites now of receivership? So, requisites for appointment of a receiver, number 1, a verified application filed by the party requesting for the appointment of the receiver. That is found also in section 1 of Rule 59. As the grounds, or based on the grounds stated in section 1, Rule 59, which is listed A to D. If we go back, these are the grounds. So, that is one of the requisite. And then, of course, application must be with notice and must be set for hearing. Okay? So, it shall be with notice to both parties or to the other parties and must be set for hearing. Okay? So, as a proceeding, it can also have its own hearing. But it must be in conjunction or as a part of a main cause of action. But, of course, this is an exemption to the general rule that provisional remedies are or should have main actions along with the rules of court on injunction. So these are the exemptions. They can stand alone by themselves. So this can be a main cause of action. Okay. Third, before appointing a receiver, the court shall require the applicant to post a bond executed to the party against whom the application is presented in an amount to be fixed by the court. Okay? So, remember that other provisional remedies also have their bonds. And in the receivership, it is the court that fixes the amount of the bond. Okay? So, some other remedies require that it should be equal to the value of the property. But in receivership, the court may fix the amount in according to its discretion. Okay? So, a receiver, the court shall require the applicant to post a bond, okay, before the appointing of a receiver. That is in Section 2 of Rule 59. Again, and then, before entering into his duties, so we are talking about the receiver here, the receiver must be sworn to perform his duties faithfully and shall file a bond. So, the applicant files a bond or posts a bond. The receiver himself also or herself shall file a bond, executed to such person in such sum as the court may direct. So again, the court has a discretion on how much this bond will be. So that is Section 4, Rule 59. Letter C, requirements before issuance of an order. So what are the requirements? There should be oath and bond of receiver. So before entering his duties, the receiver shall be sworn to perform them faithfully and shall file a bond executed to such person and in such sum as the court may direct, to the effect that he will faithfully discharge his duty. What is the purpose of the bond? Is so that the receiver will faithfully discharge his duty. And of course, the oath. Okay, so you can find that in Section 4 of Rule 59. Now, what are the general powers of a receiver? Okay. So, the powers of the receiver, subject to the control of the court in which the action or proceeding is pending, a receiver shall have the power to, number 1, or letter A, bring and defend in such capacity actions in his own name. B, take and keep possession of the property in controversy. C, receive rents. Okay, if the property is rented or leased, he will now receive the rent or lease fees of that property. Letter D, collect debts due to himself as receiver or to the fund, property, estate, person, or corporation of which he is the receiver. Okay? So, as a receiver, he can collect the debts due to himself as functioning as a receiver. In other words, he can collect his pay, he can collect fees for being a receiver, and he can also collect debts due to the property, to the fund, which he is the protector or receiver, to the estate, to the person or the corporation. Okay, so he acts on behalf of the parties in terms of the property or in relation to the properties in the receivership. Okay, so as an example, in a when when the property and the estate gives out credit to some debtors. So if the debtor will pay or the debt is due to that debtor, the estate under the receivership that gives the loan to that certain the receiver can collect the payment of the debtor. Okay, so that is letter D. Letter E, compound for and compromise the same. Okay, so he can compound for and compromise the same for the property, estate, persons, or corporation under the receivership. F, make transfers of what? Of the property, of the corporation, and so on. Pay outstanding debts, letter G. So if the corporation or the estate or the property incurs debt, the receiver can cause the payment of such. Letter H, divide the money and other property that shall remain among the persons legally entitled to receive the same. So he will be the one to divide the money and property or the residual amount among the persons legally entitled. Perhaps when there is already judgment by the court as to whom the property belongs. So if the property in litigation. I generally to do such acts respecting the property as the court may authorize, of course, according to the uh, court's decisions, okay, or an action that the court may authorize, and invest funds in his hands only by order of the court upon the written consent of all the parties. Of course, he can do such investment. He can recommend this investment, but it should be by the order of the court and of course the written consent of all the belligerent parties of the case. So this is found in section 6 of Rule 59. What is the liability for refusal or neglect to deliver property to receiver? This refers to the parties in possession of the property for receivership. So, what are their liabilities if they refuse or neglect to deliver such property to the receiver when the receiver is already appointed? Letter A, the parties may be punished for contempt. And letter B, shall be liable to the receiver for the money or the value of the property and other things so refused or neglected to be surrendered, together with all damages that may have been sustained by the party or parties entitled thereto as a consequence of such refusal or neglect. In other words, the party who refused to or neglect to deliver property to the receiver may be liable to the receiver himself for the money or value of the property that was refused or neglected to be delivered, or together with all the damages after judgment, okay, that may have been sustained by the parties entitled thereto as to the consequence of such refusal or neglect. So if the party has already had the title to that property who applied for the receivership, but the other party did not receive, didn't refuse to deliver that to the receiver, or denied or neglected to deliver that, the party who filed for the receivership may, or the party who is already entitled to the property may file damages against the party who refused or neglect to deliver property to the receiver. Again, they will be liable to that. Okay, that is found in Section 7, Rule 59. So, in the event that the receiver also causes danger or will act uh, in contravention of what is of his duties. So what are the remedies against the receiver? So an aggrieved party may, number one, take the matter into the court which appointed the receiver and ask either for an accounting or take some other proceedings and ask for consequent judgment on the acts complained of. So the receiver actually has general powers as stated previously. So if the receiver does not follow such powers or makes an act that contravenes his duties and powers, the aggrieved party may take the matter into the court which appointed the receiver and ask either for an accounting, especially if they now say that the receiver had disposed of the property without due notice and without the authority of the court. So they can go They can ask for accounting and take some other proceedings and ask for consequent judgment on acts complained of. Or, number 2, ask for leave of court to bring him in action directly. So they can ask the court, they can have permission of the court to bring the receiver directly to the court for such an action. Note, however, that any action filed against a receiver without the required judicial authority may be dismissed through the allegation or failure to comply with the condition precedent as an affirmative defense to the action. So, filing an action against the receiver without the required judicial authority, as stated in number 1, in the rules, it can be an affirmative defense, okay, of the receiver against the party who brought a cause of action to court. So this is stated in the book of Riano in 2016, and also in the case of De La Riva versus Molina Salvador, GR number L10106, in a very old case in 1915. So what are the two kinds of bonds as being stated in this provisional remedy? The first one is the applicant's bond, as stated previously, that the applicant to the who filed the remedy will post a bond. Okay, number 1, executed to the party against whom the application is presented. So the bond is executed against the party whom the application is presented. So this is presented to the other party. Okay. Second, in the amount to be fixed by the court. So it is in the discretion of the court to fix the amount of such bond. Number 3, to the effect that the applicant may apply or will pay such party all damages he may sustain by reason of the appointment in case the applicant shall have procured such without sufficient cause, the court may, in its discretion, at any time after the appointment, require an additional bond as further security for such damages. Okay, so the applicant or the court may require the applicant to pay more or to have an additional bond if the court may find that the appointment was caused by fraud or other causes. Okay, so that is in Section 2, Rule 59. The second one is the receiver's bond. Now, as we have said, that the receiver will also fill out a bond. And as written here, number 1, before entering into his duties, he should fill out a bond. Second, executed to such person. So it is executed to himself. And number 3, in such sum as the court may direct. So this is in the discretion of the court. And 4, to the effect that he will faithfully discharge his duty in the action or proceeding and obey the orders of the court. So aside from taking an oath for his duties, he is required to post a bond so that the purpose of that is he will faithfully discharge his duties in the action or proceeding and obey the orders of the court. Because if he will not, such bond will be used as a payment for not doing his duties, not discharging his duties faithfully. Now, there is also a counter bond on opposition for appointment of a receiver. If there is an applicant who posts a bond because he filed an action for receivership, but the opposing party will oppose the appointment of such a receiver, that opposing party shall also post a bond, which is called a counter bond. So the party against whom the application for appointment of a receiver may oppose the application or ask for the discharge of a receiver already appointed. Okay, so If there is already an appointed receiver, they can also ask for his or her discharge. To make a successful opposition, such party should file a bond. A, or first executed to the applicant. So this is executed against the applicant. And in an amount to be fixed by the court. Again, this is according to the discretion of the court, and to the effect that such party will pay the applicant all damages he may suffer by reasons of acts, omissions, or other matters specified in the application as ground for such appointment. So, again, in Section 3, Rule 59, the posting of the bond by the applicant and the posting of counter bond by the opposing party has the same purpose. Okay, so that it can be used for the damages that he may suffer, or to pay for all the damages that the applicant may suffer because of that opposition as filed by the opposing party. Okay, so when does a receivership be terminated? Let us talk about the termination of receivership. So there is only one ground for the termination of receivership, that the necessity of a receiver no longer exists. So there is already a final judgment, or it was already executed properly, faithfully, or the property has already been disposed of, and the amount or the value of the sale has already been apportioned to the parties. So there is no need of receivership anymore. So that is found in Section 8, Rule 59. So the receivership is terminated. So what is the procedure for termination? Number one, first, the court shall determine that the necessity for a receiver no longer exists. Through or by motu proprio, or as the court will act on itself, or on motion of either party. So the court may in itself make a determination that the necessity for a receiver no longer exists, or either party can file a motion that the necessity for a receiver no longer exists. Okay. Number two, or the second one, is due notice should be given to all interested parties. So if there is a determination now of the necessity for a receivership, so that it will be terminated, all parties should be notified. Okay, there should be due notice to all interested parties. And the third one is hearing shall be conducted. And fourth, after due notice and hearing, so the court shall, number one, settle the accounts of the receiver. Okay, so if the receiver had disposed of, had collected rents, had to collect his fee for the receivership, he has to settle, or the court shall settle the account of the receiver. Direct the delivery of the funds and other property in his possession to the person adjudged to be entitled to receive them. Okay, so if there are parties now entitled to such property, he or the receiver is directed to deliver such property or funds in his possession. Order the discharge of the receiver from further duty as such. There should be a discharge so that there would be a closure to that duty. So the receiver will no longer do his duties for that receivership, and allow the receiver such reasonable compensation as the circumstances of the case warrant, to be taxed as cost against the defended party, or appointed a portion as justice required. Okay, so the receiver should have a reasonable compensation, of course, according to the circumstance of the case. And of course, this can be taxed against the defeated party or can be apportioned among the parties in the litigation as justice may require. Okay, this is Section 8 of Rule 59. And that ends our receivership for the Provisional Remedies Rule 59.